Thank you. Good afternoon, and for some of you, good morning. My name is Guy Wilkes, and I'm a partner in our London office and member of the firm's Financial Services Regulatory and Enforcement Group. Before joining Mayer Brown last year, I headed an enforcement department within the UK's Financial Conduct Authority. Joining me today is Dan Stein, a partner in Mayer Brown's New York office and leader of the firm's Global Regulatory and Investigations Group and co-leader of the White Collar Defence and Compliance Group. Dan joined the firm late last year after serving as Chief of the Criminal Division for the United States Attorney's Office for the Southern District of New York. Before we begin, I have one or two housekeeping announcements. First, as we go along, we hope that you'll ask questions by using the Q&A panel on the right side of your screen. We'll make every effort to answer questions towards the end of the webinar. However, if we are unable to answer your question during the presentation, we'll follow up with you directly once the webinar has ended. Secondly, regarding CLE credit, we will be providing an alphanumeric code at some point during the presentation, and in order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. Finally, I have one caveat. The views that Dan and I express today are our own and should not be attributed to our firm or our clients. So thank you very much, and I'd now like to hand over to Dan.
Okay, thank you very much, Guy, for that introduction, and I'll just get started. So we're going to discuss today developments in enforcement in the financial services industry in both the U.S. and the U.K. I'm going to speak first about some developments in the United States, and then I'm going to turn it over to Guy to address some developments in the United Kingdom. With respect to the developments in the United States, there's really two broad topics that I plan to discuss. First, I have some comments about what we can determine about the emerging enforcement priorities of the Trump administration. And then secondly, I'll address some recent developments in enforcement cases involving the U.S. credit markets. So first, with respect to the emerging enforcement priorities of the Trump administration, I think the first point that must be made is that we are still very much in a period of transition. Even though the election occurred last November and the new administration began in January, here we are in June, and there are many vacancies across the federal regulatory commissions, including, as is most relevant to the financial services sector, including many vacancies at both the Securities and Exchange Commission and the CFTC. And as the Wall Street Journal helpfully reported just in the last day or two, this can often result in stalemates because if you have two commissioners, for example, at the CFTC, one Republican and one Democrat, it's hard to get a majority to vote on any particular matter. And similarly at the SEC, where you have only 3 commissioners in place and 3 votes required for a new rule, it can be very hard for a new rule to be passed. But I think one point that is important to make when it comes to the question of enforcement is that we have to differentiate between regulation, that is the passage of new rules, the amendments of rules, the elimination of rules, or other matters like that. We have to differentiate regulation from enforcement. And while the vacancies at the SEC and the CFTC may make it very hard to move forward with regulation, with new regulations or the repeal of regulations, it's not necessarily the case that it will also follow that there'll be a lack of enforcement. Both the SEC and the CFTC have shown in the past several months that even with the vacancies that exist on the commission level, they're able to move forward with enforcement matters. And in fact, I would say that just in the last several months, the outlines of a leadership team on the enforcement side are beginning to come together. So we have, as of earlier this month, the Senate confirmed President Trump's nominee, Jay Clayton, to be the chair of the SEC. That was the first step in getting the leadership team in place on the enforcement side, and there have been recent news reports, though nothing formal, that indicate that Chair Clayton is likely to name Stephen Pekin, a partner at Sullivan & Cromwell, and Stephanie Avakian, the current acting director of enforcement, to be co-directors of the Division of Enforcement going forward. Similarly, on the CFTC side, President Trump has nominated the acting chair, J. Christopher Giancarlo, to be the permanent chair, and the CFTC has appointed James McDonald to be the director of the CFTC's Division of Enforcement. I think what we see from this is that on the enforcement side, again, differentiating that from the regulatory side, on the enforcement side, we're likely to see, in a broad sense, continuity of the enforcement priorities of the prior administration. On both the CFTC and the SEC side, the individuals who have been identified as the new enforcement directors are experienced professionals. Mr. McDonald at the CFTC is somewhat less experienced. He's quite young and has not worked at the CFTC before, but nonetheless, he's a former federal prosecutor from the Southern District of New York, and someone who I think has shown a commitment to law enforcement and prosecution. Similarly, Mr. Pekin is a former prosecutor from the Southern District of New York and is a very experienced practitioner in the securities enforcement field, and someone who has practiced in this space for a long time, and someone who I would expect to broadly continue with the enforcement priorities of the prior administration. Now, if you turn one's attention to the Department of Justice, there's a somewhat similar situation. There are many, many vacancies remaining at the Department of Justice, including all of the United States attorneys. It was widely reported, and many probably know, that President Trump, back in March, asked for the resignations of all remaining United States attorneys from the Obama administration, and all but one resigned, and that one was fired. Since that time, since March, there have been no nominations for new United States attorneys, but the vacancies even extend beyond that. There obviously is an Attorney General in place, Attorney General Sessions, and a Deputy Attorney General, Rod Rosenstein, who are, I think, settling into their positions. But as you move down the organizational chart within the Department of Justice, there are still many vacancies and many positions held by acting officials. For the criminal division, the division of most interest for this presentation, there's been an individual mention in the press, but no formal nomination. At the fraud section, which covers many of the topics that will be of interest here, the recent news was that the former head of the fraud section, a lawyer named Andrew Weissman, recently moved over to work for the special counsel, Robert Mueller, and his deputy has moved into that position in an acting capacity. The only real new senior official who's in place is a gentleman named Trevor McFadden, who is named to be what's the principal deputy AAG in the criminal division. And from what I can tell, he appears to be, again, a very experienced practitioner in this area who has spoken broadly about basically a desire to have some continuity and enforcement in this space, and I'll talk a little bit more about that in a moment. The final point I wanted to make about this is at the Department of the Treasury, where the sanctions enforcement is important. Again, the President has nominated a former federal prosecutor and an experienced lawyer, a professional, to fill one of the key roles there, which is the Undersecretary for Treasury for Terrorism and Financial Intelligence. The comment I wanted to make about the emerging priorities at the Department of Justice emerges from the fact that as the new administration came into place, there were many people who speculated or predicted that there might be a reduced focus on white-collar crime enforcement. It's not entirely clear what the basis for that prediction was. Some pointed to the anti-regulation stance that President Trump articulated during the campaign and in the early days of his administration. Some pointed to the administration's seeming focus on violent crime and immigration offenses, and some pointed to the general business-friendly tone of the new administration. I think there's reasons to be skeptical about those predictions. First, as I said before, there's a clear difference between regulation and enforcement. And even though the President has said he wants for every new regulation to have 2 regulations removed, that doesn't mean there'll be a lack of enforcement of existing regulations or the rules against fraud or other types of criminal behavior. Secondly, while it's true the Department is focused on violent crime and immigration offenses, that doesn't mean that they're not going to have resources devoted to white-collar crime. And in fact, the Department has a long history of being able to do both types of things at once. And thirdly, to the extent that this prediction is based on a general business-friendly tone, I would say that there are many business-friendly people and many people in business who are nonetheless committed to anti-fraud and to enforcement of the rules that when people violate those rules. And I think to sort of show that these predictions are, that my sense of this is shared by some members of the administration, I thought I would walk through some recent statements that have been made by the existing leadership of the department. Starting with Attorney General Sessions, who made a point of announcing at a speech last April that as we redouble our efforts to combat violent crime, we will still enforce the laws that protect American consumers and ensure that honest businesses aren't placed at a disadvantage. He added, this Department of Justice, referring to the new administration's Department of Justice, will continue to investigate and prosecute corporate fraud and misconduct, bribery, public corruption, organized crime, trade secret theft, money laundering, securities fraud, government fraud, healthcare fraud, and internet fraud, among others. Not to be outdone, the Deputy Attorney General just last month also announced that the department remains steadfast in its commitment to protecting our nation's financial system by thoroughly investigating and aggressively prosecuting fraud cases. And lastly, Mr. McFadden, in a speech last April, specifically and explicitly took on this prediction that some had made about a reduction in enforcement on white-collar crime. He said, today I would like to address the suggestions from some that the Department of Justice is no longer is interested in prosecuting white-collar crime. And as you can see, he added, I intend to dispel that myth. So again, it seems to me that notwithstanding some of these predictions, the signal coming out of the new leadership of the department is that they intend to continue to investigate and prosecute white-collar criminal cases. Specifically on the FCPA side, Mr. McFadden has given a series of speeches in which he's, just in the past few months, expressed continued enthusiasm for FCPA enforcement, notwithstanding some of the comments that President Trump may have made on the campaign trail, and specifically citing to Attorney General Sessions' statements during his confirmation hearing that he intends to fully enforce the FCPA. In that context, he's also spoken expansively about the focus the department will have on cooperation and voluntary compliance by corporations, as well as the continued emphasis on individual accountability, which many associate with the Yates memo from the prior administration. And lastly, Mr. McFadden has emphasized the importance of international cooperation in this area and the fact that many jurisdictions outside the United States are seeming to increase their focus on international corruption, and that the Department of Justice is going to work hand in hand with those other jurisdictions. Now, one final comment before we turn to the next topic, which is the trends in the credit markets. There are many who have asked me and many who have also speculated that we may be seeing a point where the trend of escalating and eye-popping settlements from the financial services industry, that trend may be cresting, and we may see that we won't see, continued cases day after day with multi-billion-dollar settlements. And I think it's fair to say there are some hints, if you look closely, that that might be the case. In one of Mr. McFadden's speeches, he made a point of saying that the fraud section's aim is not to, quote, break our own records for the largest fines, which may be may have been intended as a signal on this front. Secondly, I'd point to the fact that the department and the incoming leadership of the department continues to stress individual accountability, which may be a way to differentiate from large corporate settlements. Outside the department, we've seen just in the last week or so, a federal judge in the Eastern District sharply chastise prosecutors there for entering into a deferred prosecution agreement with a large settlement and not prosecuting individuals. Perhaps even the Supreme Court action from yesterday, which addressed SEC disgorgements and ruled that they were properly considered a penalty for statute of limitation purposes, might reflect a sense that the legal community is looking to see less of these multi-billion-dollar settlements. But I want to make three comments about this prediction that the various people are making and are looking for. Number one is that even if these trends have crested, things may not change quickly. In many cases, the large settlements that have caught lots of attention were really the product of the nature of the cases that were being brought. They were cases where the large settlements were keyed to restitution amounts that were owed to victims based on the mortgage crisis and other wrongdoing. And I can tell you from the perspective of a prosecutor, when they come to view the funds in question to be restitution or money that properly belongs to a victim, it's very hard for a prosecutor to walk away from that or bargain that down with a company, because they see that as not their money to bargain away, but as the victim's money. Secondly, I think to the extent we see other jurisdictions following suit by seeking large corporate penalties, that's going to create a situation where the U.S. authorities won't be seen to be placing an unfair anti-competitive advantage on certain companies, because they will not be outliers compared to other jurisdictions. So we may not see things change as quickly as some might expect. Secondly, I would say to the extent we are going to see smaller corporate settlements, maybe people should be careful what they wish for. The department, again, has emphasized they continue to focus on individual accountability, and I think criminal investigations of individuals within a corporation can still be very disruptive to business and may come at substantial cost. There also may be, along with a reduction in corporate fines, a greater insistence on corporate monitors and other types of reforms that could also be quite costly as well. And third, I would say that people in the financial services sector shouldn't take any false comfort if they think that the wave of massive corporate fines is behind us. You know, even before 2009, before this wave of multi-billion-dollar penalties, people in the financial services industry were nonetheless concerned about enforcement matters and the types of penalties that could be assessed. It's amazing to see that today, when we just see in the news penalties imposed, a forfeiture imposed in the Banamex case of $97 million and a fine imposed in a Deutsche Bank matter for $40+ million. Those don't seem to get any attention at all because the numbers seem small in a relative sense, but I would suggest they're still quite substantial and not something to be ignored. And then finally, the last comment I'll make on this point is there's also a long history when the federal government didn't seek such large corporate fines. We know well in New York that there was a state AG named Elliot Spitzer who filled the void, and many state AGs since the election this past November, especially in states that are controlled by Democrats, have shown an increased interest in pursuing corporate white-collar crime cases because of the perception, right or wrong, that perhaps the federal government may not be as focused on this as it was in the past. So I think folks would still be wise to consider the consequences of enforcement matters in this space, because even if there is a reduction on the federal side, we could certainly expect the state to try and step in. Now, before I move on to the developments in the credit markets, I wanted to give Guy a chance to weigh in on the changes that might be occurring in the UK in light of the election that I know is coming up later this week. Guy, do you have any thoughts to offer on that?
Yeah, thanks, Dan. So as we reach the final days of the election campaign here in the UK, the gap between the incumbent Conservative Party and the opposition Labour Party is decreasing, but the polls are still predicting that the Conservatives, the incumbents, will remain in. What has been disappointing, I think, for those in the financial services industry and industry in general, given that the main task of the new government will be to negotiate the UK's exit from the EU, the disappointment is the lack of focus on that in this campaign and indeed in any of the manifestos of the parties. So there has been virtually no discussion at all of the financial services industry or any clue which will assist the industry in preparing for Brexit. That's disappointing because, again, it means firms are finding it difficult to plan, but also the concern is that the lack of focus will continue after the election and in negotiations, financial services will at worst be seen as something which can be negotiated away. So that's disappointing. One surprise in the Conservative manifesto which will affect financial services firms and indeed other firms is the announcement that Theresa May, if she gets re-elected, will abolish the Serious Fraud Office, which is the main prosecutor of corruption and white-collar crime in the UK, and the intention is that the SFO's activities will be subsumed into another organisation, the National Crime Agency. Theresa May's expressed wish is that will increase cooperation and intelligence sharing between white-collar crime and the more intelligence-focused National Crime Agency, but the proposal has been universally condemned by virtually everyone in the industry, including lawyers and firms themselves. The concern is that white-collar crime and corruption will move down the priority of the new government, and indeed a concern is that it's just being used as an opportunity to perhaps reduce funding for this area. So that is a concern, and if the Conservatives do get in and intend to put this in place, one can expect to see quite a degree of opposition, both in industry and possibly even in the Conservative Party itself. So, as I say, some disappointment in the UK as to how the election is going at the moment. Okay, so with that, I'll hand back to Dan.
Okay, thank you very much, Guy. So I wanted to address some enforcement development in the U.S. credit markets. And there's obviously much to be said about these cases. I don't want to pretend to be exhaustive here. I'm bringing it up only because I think it illustrates a couple of points that are important for people to bear in mind, and because it may be something that as we look around the corner, we may see more of in the coming months. I've listed here two cases, U.S. versus Jesse Litvak and U.S. versus Ross Shapiro et al., as examples of cases that were brought in the credit markets involving sales practice. The 2 points that I think these cases illustrate, number one, is that these are cases in a trend that we're seeing that is not top-down. It's not a decision based on the leadership of the regulatory agencies or the leadership of the department to say, well, you know what, we should focus on the credit markets now as opposed to something else. They're really developments that have emerged from the bottom up based on referrals that were made and investigations that were done and experience that was gained. The second point that these cases illustrate is the way that federal investigations and prosecutions tend to build upon one another as investigators and prosecutors develop expertise in a particular area, and perhaps more importantly, as witnesses and people who are implicated in these investigations become cooperating witnesses and try, in an effort to earn leniency for themselves, they look to disclose information about others who might be involved in wrongdoing. And if you're someone who's a trader in the credit markets and you're looking to do that, the only area where you're likely to have information will be other people in the credit markets. And so I'm going to explain what I mean by that in a moment, but I think it's worth thinking about when we think about these cases. So briefly, I know the Litvak case is now a couple of years old, so people may be familiar with it, but for the sake of everyone, I'll just give a brief summary. Jesse Litvak was a mortgage bond trader who was initially charged and prosecuted for making misrepresentations about his own the prices about his own book, about the prices at which he acquired bonds that he was in turn offering to resell to others. There were no misrepresentations made about the bonds themselves, only about his own price or his own trade practices. The defense that was presented was a defense based on materiality. Essentially, the defense boiled down to a claim that the sophisticated parties on both sides of these transactions are not terribly interested in what a trader might say about his or her own price, but are rather doing their own analyses of the price, and so it's not really the basis for a fraud case. The Litvak case was the first and the most prominent of these cases, but they were really, it was really one of a series of cases that was brought at many different firms across the street. There are a number of these cases. Some of them resulted in guilty pleas. Jesse Litvak went to trial and was really testing the government's theory of the case. He was initially convicted back in 2014 by a jury. The Court of Appeals later reversed that conviction, but what I think some people overlook is that the Court of Appeals reversed that conviction on grounds related to the evidentiary rulings that the trial judge made, not on the underlying theory of prosecution itself. In fact, the Court of Appeals affirmed the concept that, assuming the evidentiary rulings were correct, Litvak would be properly tried and convicted on a theory that making misrepresentations about his own price could be a material misrepresentation if a jury so found. Litvak was retried in 2016 and was convicted, this time only of one count. He'd been convicted of multiple counts the first time, but he nonetheless received the same 2-year sentence that had previously been imposed. The Shapiro case is ongoing as we speak. It is wrapping up in the District of Connecticut, and we'll see what the jury does with that case, but it presents many similar issues. What's interesting about the Shapiro case is that a witness who testified in that case disclosed in the course of his testimony that in addition to providing information about the sales practices at Shapiro's firm, he had also been cooperating with government prosecutors on an investigation on the buy side, and specifically he referred to an investigation relating to the mismarking of positions on the books of certain buy-side firms, specifically as it related to structured credit products. And this is not a totally novel type of case. There have been cases brought in the past involving buy-side firms that are holding positions in very illiquid structured credit products, and in order to mark their books, what they do is they solicit quotes from brokers in the field, and invariably, because these products are thinly traded, there's a very small number of brokers who could provide marks, and in certain cases there's been proof that those brokers were knowingly providing false marks in order to inflate the value of a position in exchange for some benefit from the buy-side firm. That is the type of matter that this witness in the Shapiro case disclosed. We don't know much about the case he's referring to because it's not yet public and it hasn't been announced, but I think based on that testimony and some reporting that was done surrounding it, one can expect to see, as we look forward to the next couple of months, more activity in this area, which may sweep up different participants in the credit markets. I bring this up mainly, I think, again, to illustrate the point that you see in the Litvak case, really it was a novel prosecution based in a market that prosecutors didn't have much experience in. They gained expertise, they tried a case, they succeeded, they're trying another case, the momentum is building, they've developed cooperating witnesses who are now providing testimony about other areas in the credit markets. And if one picks out a proverbial crystal ball, I think that's a good indicator of what we might see going forward, again, from a bottom-up perspective as a case develops, rather than from a top-down perspective as to what the leadership is thinking about. And with that, I will turn it over to Guy to address developments in the United Kingdom.
Okay, thanks, Dan. I'm now going to talk about developments in enforcement policy and law in the United Kingdom. And like in the US, as Dan spoke about, the UK is increasingly focused its enforcement attention on individuals rather than firms. So I'm going to provide an update on how that is going. I'll also talk about some changes to the FCA enforcement process, which is significantly impacting firms under investigation. And finally, I'm going to say something about cross-border enforcement and investigations, and in particular, developments in the law relating to privilege, something which affects anyone conducting an investigation which may have a UK connection. So firstly, individuals. Now, following the banking crisis in 2008 and multiple conduct failures in banks and other financial institutions, enforcement against banks and the size and number of fines increased exponentially, and it's fair to say that amongst the general public in the UK, the expectation was that this enforcement activity would also extend to individuals. However, the reality was somewhat different. The most high-profile bank failure was HBOS, which had to be rescued via a Lloyds Bank takeover. However, the only enforcement action against an individual to face formal sanction was the head of corporate lending at the Bank of Scotland, Peter Cummings, and his views are clear from the quote on this slide. Now, even senior executives at the FSA, as the predecessor to the FCA was called, even senior executives agreed that individuals managed to avoid sanction. And indeed, the former director of supervision at the FSA accepted that the most blameworthy managed to escape. Since then, the FSA and its successor, the FCA, has been determined to bring more enforcement focus on individuals, as they've made clear in each one of its annual reviews published since 2013. In addition, the regulators have been subject to a degree of external scrutiny, including a Treasury review into enforcement decision-making and a report by Andrew Green QC specifically into the FCA's investigation and enforcement decision-making in relation to HBOS. As a result, the decision-making process around investigation and enforcement against individuals has been made more rigorous. In particular, in all cases or potential cases, the FCA creates a dramatis personae of individuals and makes an evidence-based decision whether to refer any of those individuals. In any ongoing investigation into a firm, the FCA will keep under review the individuals under investigation, or indeed not under investigation, and at least on a quarterly basis will consider with FCA supervision whether further evidence has emerged which merits changing the mix of individuals under investigation. More fundamentally, as well as introducing changes to FCA process, the UK government has introduced new legislation known as the Senior Managers Regime. And this was introduced last year in March 2016 for banks and insurers, but will be rolled out to all financial services firms in 2018. At the centrepiece of the legislation is the requirement for all UK banks to allocate responsibility for all areas of a bank, including non-regulated activities and support functions such as IT and HR, to a named senior manager. The bank produces a responsibilities map showing how the bank is carved up between individuals, and each senior manager has a statement of responsibilities setting out what he or she is responsible for. Now, the senior managers regime is expected to make enforcement against senior managers easier because, unlike previously, where firms often had complex matrix management structures, it's now much easier to identify who carries the can for failure in a particular part of the bank. Section 66A of the Financial Services and Markets Act, FSMA, provides that the senior manager will be guilty of misconduct if there is a contravention in their area of the bank and they did not take reasonable steps to prevent the misconduct from occurring. Essentially, it's liability based upon negligence. Now, for those of you who are based outside the UK, you should be aware that there is no territorial limitation for the senior managers regime. There are a number of ways it has extraterritorial effect. For example, it applies to overseas branches of UK firms, applies to overseas persons with the responsibility for managing aspects of a UK bank. So on this slide are some examples, and for some reason I've chosen New York for the examples, but it applies everywhere. Now, it's clear that 1 year in, the FCA is pleased with how the SMR has impacted firms. Our clients are reporting that senior managers in the business, as opposed to compliance or legal, mindful of their own potential liability, are now taking conduct very seriously and putting significant effort into ensuring not only that they have effective systems and controls in place, but that records and documentation evidences that. And time will tell before we know whether the SMR will indeed make it easier to enforce against senior bankers, since it will take some time for the first cases to emerge. But paradoxically, because the SMR seemingly has started to modify behaviour, it may actually mean fewer cases because the banks have become more compliant. So we will see. Now, in response to a Freedom of Information request published a year after the anniversary in March this year, the FCA reported that 2 senior managers had been placed under investigation under the new rules, and more will, of course, follow. As a postscript, I should add that the Financial Stability Board, an international body that monitors the global financial system for risk, said last month that it believes the UK's Financial Conduct Authority's senior managers and certification regime is ripe for expansion. And there are reports in the press that the US Fed, the US SEC, and the Department of Treasury are among the FSB's member institutions looking closely at how the SMR has played out in the UK. So like the FCA's Project Innovate has rolled out to other jurisdictions, it may be that we see the SMR or systems based on it being rolled out to other jurisdictions as well. Dan, I don't know if you want to come in at that point and say something about the attention on individuals in the US, and in particular here in the UK we're all familiar with the Yates memo, but what steps have been taken to put that into effect?
Thanks, Guy. So as I mentioned briefly earlier, the tea leaves we're reading from the incoming leadership of the department, namely Mr. McFadden and AG Sessions when they've given speeches, they have referred to a continued focus on individual accountability. And that phrase is significant because the formal name for what we informally refer to as the Yates memo is the individual accountability memo. So that phrase is clearly referring back to the Yates memo and suggesting that it's not going to be rescinded. I think very briefly we could have a whole panel discussion, obviously, about the Yates memo, but briefly I would say that the biggest impacts have been on certain types of civil enforcement actions where the Yates memo instructed for the first time to also bring those civil enforcement actions, whether they're FIREA cases or other types of cases against individuals, and maybe perhaps in some districts within the United States that had previously not focused on individuals, the instruction clearly was to do that. In many jurisdictions in the U.S., in the fraud section, in the Southern District of New York, there had always been a focus on individuals, and so the Yates memo didn't change very much in that regard. Final point, unlike the senior managers regime, which you just described, Guy, the Yates memo is not about supervisory liability or negligence liability for failure to prevent a violation by somebody else. The Yates memo refers to holding individual executives accountable for their own conduct, and is simply, I think, reminding prosecutors to think about that even while they're trying to settle a larger corporate case. So with that, I'll turn it back over to you.
Okay, thanks, Dan. And I'm pleased to say we've got one question in, and that is a question about whether the senior managers regime has expanded the purchase of D&O coverage here in the UK. I think the answer is probably most firms already have D&O coverage in place, but it certainly has meant firms looking again at the scope and extent of the D&O coverage to ensure that it remains appropriate for the senior managers regime. So I think the D&O insurers are pleased with the introduction of the SMR. Okay, and I want to, just as an aside, turn very briefly to the UK's main white-collar crime agency, the SFO. I did mention earlier that it is planned to abolish the SFO going forward, but in contrast to the FCA and other agencies across the world, the SFO is increasingly turning its focus to some extent away from individuals and instead focusing on corporates. Now, this process began in 2010 with the introduction of the Bribery Act, Section 7 of which is a corporate criminal liability for failure to prevent bribery. And this year, similar legislation has been enacted, providing for corporate liability for failure to prevent the facilitation of UK and foreign tax evasion. And indeed, for some time, the SFO has been lobbying government to extend the scope of offending to include the failure to prevent any economic crime. Now, it's fair to say that it took some time for the SFO to get going from the introduction of the Bribery Act in 2010, with first corporate prosecution and conviction in 2016, last year, a first Deferred Prosecution Agreement, DPA, in November 2015. However, this year there has been some high-profile DPAs with both Rolls-Royce and Tesco. So I would have said that the SFO is on something of a roll, but as I say, its days may be numbered going forward. Next, I want to move back to the FCA and talk about some FCA change of process. In September 2015, a new Director of Enforcement, Mark Stewart, joined the FCA from the Hong Kong regulator. And he is instigating a number of significant changes to how the FCA is approaching enforcement, and these will significantly affect those firms who face the prospect of an investigation. Firstly, one welcome development is that the FCA has put in place project boards consisting of senior enforcement staff to provide oversight of cases, usually in the form of monthly meetings with investigators. This hopefully will have the beneficial effect of achieving a more consistent approach to cases across the division, as well as providing oversight and challenge to investigation teams. But more importantly, the FCA has changed the approach it takes to putting firms and individuals under investigation. In the past, early investigative steps and assessment of cases was often undertaken prior to the formal appointment of investigators within the enforcement division. Now, there were a number of reasons for this, in particular a desire to focus enforcement resources on only the most serious or most important cases, which did mean some cases were dropped prior to investigators being appointed, often through lack of evidence or because the matter could be dealt with using supervisory rather than enforcement powers. There was also a recognition among some within the FCA that appointing investigators, even if the investigation ultimately leads nowhere, can cause serious detriment to the firm or individual under investigation whilst the investigation is ongoing. For example, typically individuals are often suspended, face substantial legal costs, and it can be impossible to move jobs within the industry during the period of investigation. And so the FCA was careful and perhaps in the past too careful, to appoint investigators only where the evidence was reasonably strong. However, what we're now seeing is that the FCA's current practice is to formally appoint investigators much earlier in the process, very soon after it first becomes aware of circumstances that might indicate the wrongdoing. And the FCA has publicly accepted that this will result in a far greater number of cases being dropped without formal enforcement. As such, whilst there have been a substantially greater number of investigations commenced, it does not necessarily follow that this will result in a larger number of outcomes at the end of the day. Now, this change of approach can be illustrated by looking at insider trading investigations launched against individuals. Note, these are investigations started but not completed. But if you look at the figures for 2016 and the projected figures for 2017, one can see an enormous increase in the number of investigations commenced, and this largely reflects this change in approach. The other change in approach is that the FCA is far more reluctant to settle cases early in the investigation, and the current practice is now to complete a full investigation pretty much on all issues before any question of settlement will be countenanced. Also, in terms of settlements, the FCA wants to move away from a position where virtually all firm cases are settled by the Enforcement Division before it gets to the formal disciplinary process involving the FCA's Independent Regulatory Decisions Committee or the Tribunal. And Mark Stewart has stated publicly that he dislikes settlements, considering that they lack the transparency of a decision following an adversarial hearing. So, to encourage firms to take on the regulator and not settle, the FCA has instigated a new settlement procedure. In the past, firms were encouraged to settle by being provided with an automatic 30% discount on the fine for doing so. However, going forward, firms are now able to settle liability and dispute penalty before the RDC and Tribunal and still retain the 30% discount. Smaller discounts will also be available for partial settlement of facts or liability. So, where are we? Well, we have a situation where it's likely there will be more investigations commenced, which will be more rigorous and with fewer settlements. However, with enforcement resources remaining static, most lawyers expect there will be fewer actual outcomes despite the increase in investigations. And this seems to be being played out at the moment, where there has been a significant drop in published outcomes in 2016 and 2017. Now, in terms of the types of cases the FCA brings, we've already said a greater focus on individuals, but there'll also be more emphasis on financial crime, including AML, and market abuse, rather than some of the cases that we may have seen in the past involving mis-selling to consumers. And for those latter types of case, we're likely to see the FCA shift focus away from fines towards ordering redress. And this was demonstrated in the very recent Tesco investigation, where we saw the FCA imposing a redress scheme to compensate investors suffered through purchasing shares in a false market created by Tesco, but with no fine. And the Tesco outcome also evidences another change in approach. So in the past, the FCA has avoided taking any action against firms where the SFO is also taking action. However, with Tesco, the FCA action was coordinated with that taken by the SFO, and so seemingly firms now face the possibility of parallel investigations by the FCA and SFO. Now, parallel investigations by domestic regulators and prosecutors is, of course, common in the USA, but is an unwelcome import to the UK. Finally, I wanted to talk about international investigations and some developments concerning the law of privilege, which you need to be aware of if you're involved in any matter with a potential UK angle. Now, the high watermark of cross-border matters was probably the LIBOR and FX benchmark investigations. Now, these resulted in significant cooperation between the UK, US and other regulators, resulting in concurrent fines against a number of firms. Since those matters, whilst not as high profile, behind the scenes the FCA continues to cooperate in sending and receiving requests for information to and from overseas regulators, as this slide shows. And the slide shows a steady exchange of information over the last 3 years with both US and other regulators. However, in the UK, the real development is being played out in the courts, and it concerns English law of privilege as it applies to internal investigations. And there are 2 recent cases of note. The first one was December last year and involves the RBS rights litigation. As a corporation can only act through its employees, it used to be assumed that all employees' communications with the corporation's lawyers will be privileged. Now, in 2003, the Court of Appeal held that this is not necessarily the case. Only communications made between those authorized by the corporation to seek legal advice on its behalf and its lawyers will be privileged. Now, in the RBS rights issue litigation in December, the claimant sought disclosure of transcripts, notes and other records of interviews with RBS employees and ex-employees made as part of 2 separate internal investigations, one following an SEC subpoena and the other to whistleblowing allegations. Now, RBS resisted disclosure on the basis that the notes were subject to legal advice privilege. Alternatively, that all the notes which had been prepared by lawyers were protected from disclosure as the lawyers' privileged working papers. Now, all the claims to privilege failed. Now, firstly, while the first investigation was essentially a US investigation following a US subpoena, the court held that the law relating to the forum of proceedings under which the disclosure is sought is the appropriate law. In other words, in this case, English law. And in applying English law, employees of RBS are not the client for privilege purposes, and so communications, in other words, an interview between lawyers and the employees, are not privileged. And accordingly, a note of that interview, even if prepared by external lawyers, is not privileged. Now, the second case decided last month is SFO and ENRC. Now, in that case, the company, following an agreement with the SFO, instructed lawyers to investigate allegations of corruption with a view to self-reporting to the SFO. However, the company then changed its mind and sought to claim privilege over interview notes generated during the process. But unlike in the RBS case, ENRC sought to claim litigation privilege, arguing that an SFO prosecution was clearly in prospect. But the argument was rejected. The judge found that the purpose of the investigation was to self-report and avoid prosecution, and therefore does not attract litigation privilege. So where does that leave the privileged position in the UK? Well, firstly, for an internal investigation not connected to litigation, it's almost impossible to claim privilege over interview notes and indeed many other documents generated during an investigation. Even where authorities so how does one proceed? Of course, one can accept that interview notes won't be privileged and proceed accordingly. After all, for a purely factual investigation, one might take the view that the facts would emerge in any event. An alternative approach is possible: to investigate without generating documents that don't attract legal privilege. However, this does mean not taking notes of an interview, but instead referring to the factual matrix in a privileged report from lawyers containing legal advice. However, large investigations, of course, may be difficult to manage on that basis. Furthermore, if you don't have the notes to share with a prosecutor or regulator, you may be accused of a lack of cooperation for structuring the investigation in that way. If you do structure an investigation such that it is privileged, however, note that in the UK, the FCA is usually prepared to accept a privileged report on a limited waiver basis so as to preserve privilege against third parties. Although that can't fetter the FCA in how it does use the report, so if parts do get published or passed on to overseas regulators, you may lose the privilege anyway. And of course, such limited waiver may not be recognised in other jurisdictions. So if you're listening to this outside the UK, you may take the view that this doesn't concern you. However, remember that the law of privilege applies is that of the local forum. So, for example, an investigation conducted entirely in the US, you may think you're conducting an investigation in a privileged manner under US law, but where the company is subject to subsequent overseas litigation or investigation by an overseas regulator, you may find it's not privileged for those purposes. Note, those decisions have been subject to a fair amount of criticism, and the matter is ripe for a review by the UK Supreme Court. And lawyers in the UK are waiting to see if an appropriate case gets there. Okay, that's the end of our presentation. Thanks very much, everyone, for attending. As I mentioned before, if you submitted a question that was not answered, we will follow up with you directly. Should you have any additional questions related to today's topic, please email them to Erica Weber at eweber@mayorbrown.com, and your questions will be promptly forwarded to the speakers. Thank you again for your participation, and have a great day. Thank you.